Good morning. Today we are going to continue the previous lecture which was there on compensation, damages. What are damages? Monetary compensation which is being provided for the injured party, the person whose rights are being violated. The concept of compensation is mentioned in section 73, 74 and 75 of the contract law. Okay. Now one case is there, Hadley versus Baxendale. Based upon this case, Justice Alderson has given certain prepositions, certain rules. Based upon this case only, our section 73, 74, 75 is based. Means here in this case it was told that which compensation, which damages can be granted and which cannot be granted. And that law is in section 73. Okay, we will see the facts of the case. In Hadley versus Baxendale, the facts of the case are like a machine. It was a part of a machine which is called as a shaft was given for repair. But while giving for repair, the person did not make time as an essence of contract. Neither he told the person that he has to give the shaft repaired in these days, and if you don't give, something is going to happen. The mill is going to face lots of loss, you can say. Nothing was told. Means he generally gave the shaft for repair, and that person made some delay, and the case is being filed that you are liable for the loss which has occurred. The mill was closed, so for daily loss which has occurred to the mill, you have to pay. Such a type of claim, such a type of case was filed. Justice Alderson was the judge in the case, and he clearly held that he was not liable for loss of profits during the period of delay, as the circumstances communicated did not show that a delay in the delivery of the shaft would entail loss of profit to the mill. You have not told him that time is essence of contract. What loss has occurred? What loss will occur? How much profit he daily has and all. Nothing is been mentioned. So he will not be liable for the profits, the daily profits which the company, which the mill would have got. Okay. Now in this case, Justice Alderson mentioned certain rules. Now these rules are already there in our Indian Contract Act. Okay. The basic principle for breach of contract, or the basic principle for granting compensation, is what? Give such a compensation that the other party will be relieved. He will feel that yes, justice has occurred. And that principle is what? Restitutio in integrum. Restitutio in integrum. Restitute, put that person into the original position, or put that person in a position that he will feel that the contract is being fulfilled. Okay, that is called as restitutio in integrum. Keep the person into the original position. Okay, now the case suggests that how much or which kind of damages, which kind of compensation you will get. Compensation or the damages arising naturally, which are called as ordinary damages, which are called as direct damage or direct damages, the person is going to get. When a contract has been broken, the injured party can recover from the other party such damages as naturally and directly arose in the usual course of things from the breach. This means that the damages must be the proximate, that is direct, proximate consequence of the breach of contract. So you can ask for this direct loss. Okay, this is called as a ordinary damages. This is the first. Second is what? Damages in contemplation of the parties, as clearly it is mentioned in section 73. Damages in contemplation of parties, which is called as special damages. Damages other than those arising from the breach of contract may be recovered if such damages may reasonably be supposed to have been in contemplation of both the parties as the probable result of the breach of contract. Means I knew that if I make a breach, you will suffer this loss. Means I had the knowledge of that. So I'll be liable for the loss. It will not be remote, it will be direct, because I had the knowledge. I had spectated what loss will occur. Therefore, I will be liable. Such damages are known as special damages, and special damages cannot be claimed as a matter of right. You have to prove that the other person had the knowledge. If you are successful in proving that the other person had the knowledge that what will happen to me, then you can claim for special damages, which is called as damages in contemplation of the parties, that is within the knowledge of the party. Okay. Now, when you file a case for getting compensation, you can ask for ordinary damages, you can ask for special damages, you can ask for nominal damages also. Nominal damages means that is not a large amount, a small amount you will get as a nominal damages, where the injured party has not in fact suffered any loss by reason of the breach of contract. The damages recoverable by him are nominal. These damages merely acknowledge that the plaintiff has proved the case. Okay, so he has come, he has proved the case, but he has not suffered that loss, but he is having a right. The party is not injured by loss. The party is injured by breach of right, breach of contract. Therefore, yes, his right is being violated, therefore he should get compensation. Then that amount will be less. Therefore, it is called as nominal damages. If by a breach of contract there is loss of reputation, then you can ask for compensation for the loss of reputation also. Now, it must be a contract, it must be a breach of contract, and reputation should be affected. A very good example is what? Bouncing of a check. The bank has dishonored my check for insufficiency of funds, but my account has the funds. Means the bank has done the mistake by dishonoring my check. My check is dishonored in the market, my position will be lowered down. My reputation will be affected, because people will think that she gives a check without the knowledge that the money is there in the bank or not. But already I had the money in the bank, I had the money in the account, but the bank has done the mistake. But for that mistake, the bank can be made responsible because my reputation is being affected. Okay. Now, exemplary or vindictive type of damages, where the amount is very large. There the court is not going to see how much loss has occurred. Court is going to give large amount as compensation. See, civil court cannot order fine. Fine is a punishment which has been given for a crime, and that is given by the criminal court. Okay, not the civil court. The civil court is going to grant compensation. They will calculate whether it is direct, whether it is remote, whether how much, whether it was in knowledge or not. That calculation will be done, and then the civil court will grant compensation. But civil court will not give fine. But sometimes when reputation is connected again, the civil court can give compensation without calculation as a punishment, as an example for the others that you should not make a breach of contract. That is called as vindictive or exemplary damages given as a way of punishment. But in case of breach of promise, or you can say this is an example, in case of breach of promise to marry, or you can say that same dishonor of a check by a banker, court may award exemplary damages so that the bank should not do this mistake again. Okay, so this is exemplary where calculation are not been done. So you can ask for ordinary damages, you can ask for nominal damage also can be given, special damages can also be given, sometimes exemplary or vindictive type of compensation can also be granted by the civil court, and you can ask for damages for physical inconvenience by breach of contract. If you prove the inconvenience which is caused, and if the court considers that yes, okay, this inconvenience really has occurred because of breach of contract, it is direct and all, then for the discomfort, for the inconvenience also, the court can grant compensation. It is little bit difficult to assess such a type of discomfort and calculating the money and all, but you have to mitigate, you have to calculate and ask for your client the amount, and the court will grant it. If the court is convinced, okay, then the court is going to grant. Here you are asking for money, so you can ask for the cost of the decree also. Means whatever the plaintiff has suffered loss or the expenses which he has done for the case, you can ask that amount also, which is called as a cost of decree. The court may grant the cost of the case if it considers it proper. Okay, now again the question of money is there, then you can ask from the court the interest also for the whole amount of compensation to be granted till the payment is been done. Okay, now this is a part, you can say the parts where you can club together, which is called as compensation. Means for the cost of decree, for the interest, isn't it? For ordinary, direct, then nominal, for inconvenience, for discomfort, for the agony with the sufferings which I have suffered for because of breach of contract. You calculate the amount, and you, in the sense the advocate is going to calculate the amount, and he will file a case in a court and get compensation for his client. Okay, bye bye, see you in the next video.